Judge Cannon denies Trump's request to postpone his trial until after the election, but just for now. There's some other things happening here that might cause her to revisit that at a later date. She splits the motion. You can see the ruling is saying that the deadline's extension request has been granted. So Trump has a little bit more time to peruse and go through these materials and make some determinations. But the trial, the adjournment of moving this from the May trial date until after the November trial date at this time is denied. Now, we're going to go through that filing in full to see how the mechanics work and see how the dates might align, to see if this will ultimately get bumped past the election, because we know that in the January 6th case, Judge Chutkan is going to want to keep that case in March so that it butts right up against Super Tuesday and has maximum political impact. We'll see if Cannon is able to tease this out and schedule this in between all of Trump's other litigation. But before we get into the actual order from the judge, we're going to spend some time hearing from Trump's former lawyer, James Trusty, who games this out for us before the order came in. He was saying, there's some possibilities here, and we'll see what he had to say. And we've already covered the full hearing that led to this order. So if you missed that, there's another video on our channel called Chaos in the Trump Classified Documents that will give you the detail on what happened here, because this is going to detail the forthcoming trial schedule. Now, I also want to share this clip from Andrew Weissmann, because he was very upset with Judge Cannon from Florida after the hearing took place, and I thought that he let it fly during this clip where he is on a podcast called Prosecuting Donald Trump. Andrew Weissmann on Judge Cannon.
I'm done. I don't know whether it's bias. I don't know whether it's because she is inexperienced. I don't know if it's both. I suspect it is both, but I'm done. It is wholly inappropriate to have somebody with that combination handling a case like this, and so inappropriate to have that be the response. This was a classic integrity test to see whether she was capable of uttering the words to the defense that what you did was improper, and don't let that happen again. And instead, it was to the government that was notifying her of the shenanigans. I am absolutely done.
Wow, so he's pretty upset with her, huh? Well, it's kind of interesting because he really didn't do, I think, what he was fearing most. I mean, she kind of came out and didn't adjourn the trial, and she really didn't, do what he was so upset about. But we'll go through the actual order and then see what he says in response to the order, which was pretty benign, actually. But before we do, this is Trump's former lawyer who's kind of gaming out a little bit about how this is all unfolding right before our eyes. James Trusty, Trump's former lawyer, is on with CNN. They spar through some of these issues. Here's what it sounds like.
People that push those questions, I think there's a bigger backdrop, a bigger context to what's going on when it comes to some of the lawyers being challenged by DOJ. And let me just also give a broader context about the idea of obstruction. We certainly, as lawyers, would obviously look into questions of whether there's things that happened after the substantive offenses that could relate to obstruction or attempted obstruction. It's not something that any lawyer takes lightly, so I don't want it to sound like I kind of gloss over it. But to me, it's really clear that a political decision was made by a very politicized department that the best thing they have going to try to distinguish President Trump's possession of documents from then Vice President Biden's is to suggest that somehow obstruction is the difference. And that's been a narrative on this network and others, that somehow, well, you know why they're different? Because of all the obstruction. Now, we don't get any leaks out of Delaware, but we get plenty of leaks down here that relate to these different witnesses like the one you're just talking about.
Just to belabor that point for a minute, right? It's a very nuanced thing. They say the only reason Trump is being prosecuted is because he didn't give us the documents back when we asked him for them. But Joe Biden did, and we found a bunch of documents in multiple locations from him. Trump has a claim, by the way, to those documents because he was the actual president. Presidential Records Act, the Opinions Clause, and so on. Declassification, all that stuff, right, applies. Joe Biden never had that. So Joe Biden was automatically in violation of the law. There wasn't even a gray area about obstruction or any of those things. So it's nonsense, right? They're trying to apply them both. Joe Biden is not starting at the same starting line. He's starting way back. He has no basis at all to have those documents. Okay, Donald Trump did. So he had a claim, and they said it was the obstruction that then invalidates that claim, and that's what led to the charge. It's nonsense. And James Trusty is dead right about it. Now, he, flies right through that point because he's trying to make a bunch of points here, but it's a very good one.
Different because of all the obstruction. Now, we don't get any leaks out of Delaware, all to suggest that somehow there was obstruction. And I view it very differently.
But it's not suggesting, Trump fought in a subpoena to turn the documents over. You were there as all of that was going on.
Actually, no, but let me just say this. We want executives. We want anyone who's in kind of the C-suite of life and business to be able to freely talk to their lawyers and figure out, hey, can we fight this subpoena? Is there something overbroad, overly burdensome about this subpoena? What happens if we respond? What happens if we ask for more time? Those those are things that we encourage as a society. It's exactly right. And executives across this country have those conversations.
So he did try to fight the subpoena. Is that what you're saying?
No, that's not what I'm saying. What I'm saying is we are in a position where we should all be encouraging the notion that anyone that runs a business has the opportunity to talk to their lawyers about whether or not there's some sort of privileges that apply, whether they can fight it, whether they shouldn't fight it.
Okay, but a subpoena is a subpoena, Jim. But
right, whether he has a right to the documents. Joe Biden never did. Obstruction is debatable. They said it wasn't. They said we have made the determination that those are our documents and not yours. And that is not their right to do that.
Let me ask you this, because the judge seems to be indicating in Florida that she is going to delay this case. Do you think it's going to get delayed past the election?
I mean, I don't have any inside knowledge from her or her chambers or really anyone else, but I think what's driving the delays right now is not some sort of a political concern. It's the SIPA process. It's this idea that when you have classified material, you have to go through a very serious scrubbing and review and litigation long before you can enter the courtroom for the trial itself. And that seems to be bogging down a little bit, perhaps unclean hands from the government. I don't know for sure. But the bottom line is that takes time normally. And so the time frame, these kind of artificial time frames
But do you believe
for
it's going
Jack
to get
Smith,
pushed?
I think it's probably going to get pushed. I don't know whether it goes beyond the election or not. But generally speaking, SIPA cases, these classified information type cases, don't go to trial quickly because of that review. No matter everything else, no matter how many witnesses, how complex, what other defenses and motions there are, that alone usually pushes them outside of
Jim,
a year.
let me ask.
Let's ask if this was not a Trump case, okay, if this was any other case involving any other person with classified documents who had, let's say, theoretically, arguable rights to access those documents, would it happen within a year? Would it happen this quickly? No way. No way. It would take years, right? Look at all of the other cases and, cases like even Ghislaine Maxwell and many of these other cases are percolating for years.
Because obviously the last time our viewers saw you was when you were still on the Trump legal team. You no longer are. Can you just explain why you resigned from the Trump legal team the day after he was indicted in the documents case?
Sure can't. No, I mean, look, and I certainly didn't suggest to CNN that I was willing to talk about that. The bottom line is, I have a...
Wow. I certainly didn't say that I was willing to talk to you about that when you brought me on my show. Thanks for the broadside about that, Kaitlyn. Rude.
Responsibility. I'm not faulting you for asking. It's fine. I'm just telling you, I'm not a kiss and tell guy. So I'm not going to get into anything. It was the right time for myself to leave, for John Rowley to leave. Tim Parlatore left a little bit before that.
Can you just say, did you resign or were you fired?
It doesn't matter. I'm not here to try to elevate myself or disparage my former client. The bottom line is there was a logical break point. I took that break point and I don't kiss and tell.
Okay, well, let me ask you about something that happened this week, because the civil fraud case has been happening here in New York. You saw Trump was on the stand. There were some very testy exchanges with the judge. And at one point, the judge asked Chris Kise, who was brought on to be on the documents case, but is now in the New York case as well, the current attorney, to get control of him. Do you think you were better controlling him as a client?
Oh, gosh, Kaitlyn.
No, look, here's what I'd say about that. I mean, the response that was reported, and I haven't been up in the courtroom in New York. I've got other clients to serve. But the response is reported that Chris basically said, ask better questions. That actually is the right response at that situation. It's the attorney general that called him to the witness stand.
Right.
And when you call any witness to the stand that has some expertise in what they're talking about, they tend to be speech makers. I used to deal with cross-examining all sorts of experts in criminal cases as a prosecutor. Everything from fingerprints to identification to God knows what. And the reality is you get in and you get out. If you have to call this witness, and in civil cases you can call the other party, you darn well better get in and out with very tight questions and get what you want and get out. And they apparently didn't do a very good job of that.
Yeah, you're dealing with Donald Trump. Who do you think you're talking to, people? Hello, this is Donald Trump. He's been taking out politicos since 2016. Just one after another. Some of the brightest people in politics. They just come out and get out of here. And Ted Cruz and Rand Paul, whatever, boom, 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 boom. Jeb Bush, guac bowl Jeb, right? It's like, hello, don't you know who you're dealing with? And so the Trump is unhappy with his answers because Trump's answers were quite good. Get control of your client who's talking about disclaimer clauses and how every single document they put up on the screen left out one of the key points, which is about disclaimers, saying that the bank should not trust anything in Trump's statement of financial records because they need to do their own due diligence, which every bank knows, and they all do. And so he was mopping the floor with them. They didn't like it. That's why Engeron got a little irritated.
To the frustration of the judge, but the judge's ire should have been directed towards them.
Well, I mean, he said that Trump wasn't answering questions with a yes or no answer, but I'm also, I think part of it would be people say Trump is a challenging client to have. I mean, he's had a lot of attorneys who have come to work for him and then left the case. There's a bit of chaos with the New York team right now as well. When you look at this and you look at what he's been saying in the special counsel's investigation, you used to work the Justice Department. You know Jack Smith, who is the special counsel. When Trump calls him him deranged and a psychopath.
Yeah.
Do you think those are terms that you would use to describe Jack Smith?
What I would do is focus, again, as a lawyer, as somebody who's been a prosecutor altogether 27 years before I went private, I focus on the conduct. I mean, that's me. It's a different situation for a person running for president being indicted in these unprecedented and creative, and I put quotes around that, types of indictments. But the bottom line is I've seen things from the federal prosecutors in this case, including extorting fellow lawyer, that are obstructionists, that are wrong, that are over-aggressive. And that's what I call out, and that's what I continue to call out. Hey, look, Kaitlyn, it's a fun game to play. I understand.
It's not a game.
Yeah, it is.
I'm genuinely curious.
You want him to say yes or no. You want him to say yes or no, Kaitlyn. It is a game. We all know it's a stupid game.
Chris, what you think, given you've worked with Jack Smith and you used to represent Donald Trump?
I don't think America is waiting with bated breath to hear whether Jim will call Jack deranged. It doesn't matter. It's not part of my interest as an attorney. It's not really part of the public's interest. It's just kind of fun, sensational stuff. The bottom line is any client would have a right to be frustrated with the behavior that he's been facing.
That's right.
On behalf of the department, Alvin Bragg, Letitia James, and the wonderful Georgia case as well.
Big Fanny.
Look, I don't have to sign off or sign on anything that the president says, but I can tell you that the grounds for frustration, the concerns about a two-tiered system are legitimate ones.
Okay, I was going to let you go after that, but I got to ask you, you can't really call it a two-tiered system of justice. I mean, look at the number of Democrats who are being investigated right now. I think Senator Bob Menendez would argue that it's a two-tiered system of justice.
Well,
Hunter Biden, I mean, the list goes on.
You're using Hunter Biden as an example of equal justice?
I'm just saying you can't call it a two-tiered system of justice because there are plenty of Democrats who are also being investigated.
Sure you can. Bob Menendez, we'll see what happens to him, but it's probably because he was, he got a little too close to the sun, that guy.
By the Justice Department, including the...
She brings up Hunter Biden. James Trusty and I had the same reaction. Look at those eyes. He's like, what the heck? Hunter Biden, are you nuts, lady? Look at that right there. What? Hunter Biden, are you crazy? The dude, they were going to give him a total diversion deal for a whole mountain of criminality that he did on the back of the Biden family name. She knows she got busted there too. Oops, bad example. All right, so that's CNN, giving it their best shot. And it's fun to watch them spar a little bit. But all right, now, we finally got the ruling, right? The question is, what's going to happen with the trial? Is this going to happen in May? A trial in May is going to be a big problem because Trump is going to be in trial in March on the January 6th case. If that's 6 to 8 weeks, which it probably will be, maybe 4, maybe 8, don't know. But it'll be long. So that'll put us March, April, May. Then he'll just have like 2 weeks off, come out of that trial and come skidding into this trial. So May, June, maybe July. And then we've got maybe Georgia. And then that'll carry us up into the election. Like, it's insane that they geared all of these up right after each other so that they climax in 2024. Like, do you see? All right. So the question is this one going to move or is it going to stay on the calendar for May? This is what Judge Cannon wrote. And she splits it right now, but it's going to come back and we'll see if these issues re-emerge later down the line. 9-pager. This one coming from the Southern District of Florida, West Palm Beach Division. Of course, we know it's Jack Smith, the deranged thugs over there prosecuting Donald Trump. They're doing it on behalf of Joe Biden and the Democrats. But here's Cannon. She writes, this is an order granting in part Trump's motion to continue the pretrial deadlines, but denying, without prejudice, meaning we might revisit this, the motion to adjourn the trial. Okay, so Trump wanted two things. He wanted postponement of the deadlines and the postponement of the trial. And she says, well, the court has reviewed Trump's motions. We've seen Jack Smith's response. We've reviewed the various discovery order updates. We've seen the classified supplements, and we had a hearing on this on November 1st, the one that we covered here. We got the transcripts, did a full video on that. Transcripts came over from Julie Kelly. She says, following review, it is ordered and adjudged as follows. Cannon says, the motion to continue to postpone the pretrial deadlines are granted in part, but the motion to continue the trial, currently set for the 2-week period commencing on May 20th, is denied without prejudice. So they say it's only going to be a 2-week trial. That seems short to me, but okay. They got like 30-something documents. It's, yeah. All right. So 2 weeks in May. They say that we're going to be scheduling new conferences. There's going to be a March 1st scheduling conference, and let's look at the details. Cannon writes, she says, all right, before addressing the instant motions, the court reviews the material developments in this case. So some stuff's been happening. She says, on July 21st this year, the court granted in part Jack Smith's motion to continue trial, and we did already reset some deadlines to be in alignment with SIPA, the Classified Information Procedures Act, which makes things complicated because we're dealing with national security, classified documents, and so on. The court's decision followed a full briefing and a hearing during which the parties addressed the estimates of the voluminous classified and unclassified discovery and all the various particulars that are are related to SIPA and the extensive pretrial motions that Donald Trump anticipates, right? He's going to be loading motions to dismiss. A lot of the same things we saw in the DC case, we're going to see in this case. He says there's also going to be serious issues because there is no meaningfully developed case law, right? All of this is new and novel. This has never happened before. Never had a president who says he's entitled to his own documents that were created during his administration, over which he had opinion clause power, declassification power, Presidential Records Act power, all of the things. Never been indicted by his political opponent in an election year where the trial will be conducted. They say on July 27th, after the foregoing hearing and entry of the court's order, a grand jury returned another superseding indictment, meaning the government already, okay, we've already scheduled all of this. Like, we settled all of this, right? This is where I think some of the whiners on the other side get this wrong. They say, we granted Jack Smith's motion to continue, and we got new estimates and all of that stuff on July 21st, okay? It's settled. Hey, do you want to have lunch? Yes, let's pick a date. When's the date? It's settled. It was done. Then, about a week later, on July 27th, after the foregoing hearing, the judge says, like, we already settled this, Jack Smith returned a superseding indictment, meaning they came back and they added in a third defendant to the case. Carlos de Oliveira and another count also got added. So we got 2 defendants and 42 total counts. They say following a reasonable period of time, all the other co-defendants were arraigned, and guess what? Trump also got arraigned in August. They say in the months that followed, Jack Smith moved for separate Garcia hearings. These are going to be hearings to determine whether there's conflicts of interest between the 2 new co-defendants. And just to be clear, you have lunch, you say, hey, we've got a lunch plan, a date for 2, and it's going to, happen at this time, but I need to bring 2 other people to the lunch with me. I say, well, that's complicated. I thought you said that we were done when we scheduled it the first time. Like, I don't like to schedule things with you. We've already scheduled it. Now you're adding in a bunch of new garbage for us. In this case, this is your case. So in the months that followed, then Jack Smith, he brought in the co-defendants. Okay, he charged 2 new people, and then he brought up this Garcia hearing. He said, now these 2 guys have to settle this because there could be a conflict of interest between the 2 of them. So then Jack Smith, right, she's getting ready to, I think, she's kind of blaming Jack Smith here a little bit. He also filed contested motions. He also moved for a protective order. And those motions, styled under SIPA Section 3, they resulted in extensive filings and supplemental briefings and a sealed hearing, all as a prerequisite for the classified discovery in this case. So she's saying a lot is happening. Also during this period, the court addressed the manifest complexity of this proceeding in connection with the speedy trial reports, further reiterating the court's complex case designation and ends of justice finding under the Speedy Trial Act. And so when you designate a case complex, it gives you more time in the case, right? When we think about criminal cases at a felony level, we keep a very close eye on the clock. How much time is left? Because we have a Speedy Trial Act that says these things have to go quickly, lest your speedy trial rights be violated. And so when we ask for continuances and stuff, we exclude the time from the clock. And here, if it's designated complex, we add a bunch of time to the clock. Now, Cannon continues. She says, turning to the substance of discovery. So we're at a situation right now, just to summarize, where Trump gets charged, they schedule everything. Then Jack Smith adds in a bunch of stuff. 2 co-defendants, new charges, SIPA filings. He says, I can't give Trump this discovery unless blah, blah, blah. They go through hearings. It's super busy. Now the judge says, just so we're clear of that, like, this is going to be a problem again, I'm sure of it. And she's laying the foundation for justifying a continuance at a later date, saying, see how much work goes into this? So turning to the substance of discovery, she says, the record as it has developed in this case reflects an unusually high volume of unclassified and classified discovery, even as far as SIPA cases go, along with challenges associated with storing and handling particular information at issue in the superseding indictment. She says, every time we've been in court, these matters have been aired at nearly every hearing. First, during the initial scheduling conference in July, then during a sealed SIPA hearing on September, and most recently during the November 1st hearing, where the discovery figures were presented in a more complete and current form. But all told, Cannon says, by the latest numbers, the court is advised by the government that this case involves approximately 1.3 million pages of unclassified discovery, which is a far cry away from the J6 case, which I think is up to 12 to 13 million, which is just nuts. Approximately 60 terabytes of CCTV footage spanning at least 9 months, and 5,500 pages of classified discovery, which Trump is going to have very difficult time accessing, right? His lawyers too, they got to go and like get all their permission and see it in certain SCIF locations and all the things. Cannon says, the volume and timing of these materials has outpaced initial estimates. Jack Smith said it was going to be less than that, but it required supplementation, both in the normal course and also to correct inadvertent omissions by Jack Smith's productions. Oops, didn't mean to leave that out. Now, as far as classified discovery is concerned, Cannon says, the full scope scope of such information, including discovery directly pertinent to the substantive counts, what Trump has been charged with, in the superseding indictment, was made available to the defense only recently, on October 17th, so not even a month ago. Full scope of the discovery directly pertinent to what Trump has been charged with has just been disclosed, further contributing to the delays in the defense review. In the meantime, LSG, which is Litigation Security Group, which is the entity that certifies people and allows them to come in and, security clearance type of stuff, they remain in the process. They're managing various issues associated with the document review in this case, including the read and return requirements that have presented unique logistical hurdles not commonly present in SEPA. And finally, counsel for NADA did not receive a final clearance to review this until October, precluding him from any discovery review as well. So they haven't even read the evidence yet. Cannon says, in the midst of the foregoing, the process of establishing an accredited facility at the Northern Division remains in progress, and we're going to complete that in early 24. And the investigation in this case commenced in February 2022, but no efforts were taken to initiate the establishment of a facility until this case was indicted. Ooh, I love that. So she's blaming Jack Smith, saying, we're trying to create a facility for the defendant who's been charged in Florida to review the documents in Florida. Jack Smith, if you wanted to create a facility where that would have been easy for him to do that, you could have done so, but you didn't. Now you're waiting to establishment. That's not his problem. Finally, Cannon says the court's order on November 1st following this, we anticipate that there will be more SEPA litigation and more robust than initially forecasted by special counsel Jack Smith. He said it's not going to be a lot of stuff to fight over, but now it is. Jack Smith, now look at this. He seeks to withhold from Trump an unidentified amount of information marked as classified. Jack Smith and the deranged thugs there, they don't want Trump to see any of that unidentified amount of information. How much? Anyone know? They also seek to withhold from NADA all but one page of the 5,500 pages marked classified. And they would seek to withhold everything from De Oliveira. Cannon says these matters will be the subject of SEPA litigation to begin in accordance with the order, and there's going to be a lot of stuff to go through. A significant volume of information, more briefings, more hearings following the contested defense motions to compel. So she's fleshing this out, right? Trump, they're all going to say, no, you don't get to withhold unidentified amounts of unidentified information from us. No, litigate it. Now, all of this leads to the instant motion. She says Trump now seeks to revise the pretrial deadlines, saying we got a lot of things we need. Delays and omission in the production of discovery. Jack Smith hasn't given it to us. They've also been sizable increases in the quantity of all of the discovery. We haven't been able to access the discovery until October. We also are going to be filing motions to compel. We think that there are going to be substantial areas of dispute under SIPA. We can't even review the subcategories of the classified discovery. There's no secure facility in the Northern Division. We've got scheduling conflicts by Trump's other cases, right? Look at all these reasons. Judge, please grant us an adjournment of this trial. Now, they request an adjournment for the same reasons, but Jack Smith says, well, yeah, we might need to continue some of the pretrial deadlines that we had previously, but that's because we acknowledge that there were some delays in production, and they do need to review some of the classified discovery, and we do recognize the high volume of discovery in this case. But counsel, Jack Smith, opposes any material adjustment to the current deadlines because he says nothing material has changed since the court set the trial date, which is a little disingenuous. I mean, they added a superseding indictment, of course. The special counsel also disputes that Trump and his contention that SEPA litigation should come after motions to compel. So she says, now, the court has reviewed the instant motions, and upon consideration, here's what we think is appropriate and most prudent. Cannon writes, given the evolving complexities in this matter, it is to adjust the first batch of pretrial deadlines as specified in the chart below, and to deny as premature, meaning we can revisit this, the motion to adjourn the trial date. So is the trial date going to go, beyond November 5th? We'll see. The court says as follows. First, and most significantly, the quantity of discovery in this case remains exceedingly voluminous, even more so than initially thought. To be sure, Jack Smith has taken various steps to produce discovery on a regular basis, but even with these efforts, discovery has increased sizably from the initial estimates. Classified discovery did not become available to the defense in its complete form and on the substantive counts until October 17th. Clearance and read-in procedures have only recently reached near closure for assembled counsel of record, and discovery review as a whole has generated concrete challenges given the sheer amount of materials and the sensitivities of the information involved. And I just want to pause here because think about this. The judge is identifying all of these heavy lifts, a lot that needs to be done. This is only 1.3 million pages in this case. In Chutkan's courtroom, we're talking over 10 million pages. And she is holding her trial before this one. This one was scheduled for May. Chutkan's is scheduled for March. There's literally like 10 times the amount of evidence in the January 6th case, and she's saying Trump's team can get that done before March, right? Just to show you how insane and unreasonable her court proceeding is. So these evolving and unforeseen circumstances require a reevaluation of the initial period of the defense discovery review that was originally contemplated by our first order. Now, and they make plain to the court what due process requires. They say, Trump needs more time to review the discovery in this case, and this order aims to afford that opportunity in a reasonable fashion, balanced against the public's right to a speedy trial. Now, second, although initially projected as minimal, SIPA litigation in this case is properly understood under the text of the statute will require more time for party briefing and the court to review, given the volume of information sought to be deleted from defendants, meaning Trump cannot see it. Now, this process is going to be the same process that we covered already in DC. The government files an ex parte motion, which means they don't talk to Trump's side about it. They just submit it directly to the judge, bypassing the defense, saying that it's not simple. It must be done carefully, and there's a bunch of sensitive things that need to be presented here. And third, Trump, they represent that they intend to seek to compel discovery on those issues. So when they file this ex parte stuff and they say Trump can't get it, he's going to fight it, saying that they're not only going to try to get it from Jack Smith and the FBI, but also from other government agencies. Cannon says, I'm not expressing any view on the merits of those anticipated motions, but it is evident that the parties are at odds on significant issues here about the scope of the discoverable information, and these disagreements, which we'll put a pin in, will require substantial judicial intervention. Now, this too adds complexity to the case, both as a matter of briefing, court review, future rounds of SIPA litigation. And fourth, although less important at this stage, the court cannot ignore the realities of pre-trial schedules and trial schedules in two other matters identified by Trump. They've got a lot of things going on. They have United States versus Trump at a Chutkan's courtroom scheduled for March 4th, estimated to last anywhere from 4 to 8 weeks and maybe even more. We've also got New York case, Alvin Bragg's case, currently scheduled for March 25th. Trump is recently filing motions and trying to get the New York matter moved, currently scheduled for February 2024 with a scheduling conference. Now, although special counsel is correct that the trajectory of these matters could remain in flux, as they currently stand, they're substantially overlapping deadlines. They might move, but your deadlines overlap with their deadlines. So we got to figure it out. And so for these reasons, Cannon says, consistent with the rationale set forth earlier, and in consideration of the material developments that have come up to date, we are going to be adjusting the schedule as follows. In reaching these conclusions, the court has conducted a careful review of all the SIPA issues and has surveyed the landscape as a whole. But having done so, and finding no comparable SIPA case presenting a combination of the factors discussed therein, the court is confident that these reflect the needs of this case and the pace of complex SIPA litigation here. Now, here's the update. All of the remaining deadlines are superseded except the calendar call and the trial. Now, calendar call is the final court date before the trial. Are we still on? Is the calendar? Yep, we're on. See you tomorrow, or see you on Monday. Additional deadlines and hearings are now noticed as required. So, working backwards, right, we've got a scheduling conference and we've got the May trial date. And so you're going to see, right, we're going to have pre-trial motions. We're going to have hearings on the Section 4 motions. Now, this date is the one that really stands out because there's going to be a hearing on this date, right? February, then we'll get an order. There's going to be contested issues there. We're going to have probably maybe appeals on that, interlocutory appeals, we'll see. It's getting very close. So my point is that when there's a problem here and we have our May trial date down here, like we're getting very close, right? February, March, April, May. If this causes another round of litigation, so for example, this, like another round of these, because there are more disclosures. So Jack Smith now discloses something, but doesn't disclose the full thing. Trump says, I need to compel more. And they say, no, you don't get more, right? And we have a whole sort of circular series set of litigation that we have to go through again. And that, in theory, could be something that postpones the May date all the way down, even like at the end of November, like literally, right? You just bump it out 6 months, like 6 months literally from May, and that puts you at the end of November. And so it is an interesting ruling. We're not moving the trial date right now, but we are moving some of the deadlines, and those are coming and butting up closer to the May date. So when we get there, when we get to February and things are not settled, we still have issues with discovery, we still have issues with SIPA, we still have issues with classified documents. Trump says, I need access. They say no. Judge Cannon might revisit the trial date and bump it out. And so we'll see. Weissmann still not happy with Cannon, even though she didn't move the trial date. She says, this doesn't change my opinion. By allowing Trump to move to delay the trial, but keeping the date from now, she's blocking Fani Willis from scheduling her trial on the current Florida date. And Cannon has substantially delayed the dates for all the Florida filings, right? So he's not happy about it, which means probably a good thing for Trump. So this trial and the deadlines are going to continue on. We will be covering them all, my friends, and I hope you join us as we do. Thank you for subscribing to our channel wherever it is you're watching. Thank you for visiting robertgovea.com to sign up for our daily newsletter and get access to the mind map. All the PDFs are there, and we'll be looking forward to seeing you on the next one.